Good morning. I'm Devon Cooper. I'm the managing partner of Cooper, Barton & Cooper in Macon, Georgia, and I'm joined this morning by Dr. Wayne Johnson, who served as the Chief Operating Officer of the Office of Federal Student Aid in the Department of Education in the first Trump administration. Dr. Johnson is here to talk about a problem this morning that could be affecting each of you and impacting each of you negatively if you're a borrower under a federal student loan program or a guarantor under one of those programs for one of your children or another individual. Currently, there are 5 million individuals in America that we believe have been held to be improperly in default by the Department of Education. That number is going to grow to 10 million by the end of 2025, and we believe it'll grow to approximately 20 million in the first quarter or by April of 2026. Dr. Johnson is going to describe the scope of this problem to you, and then I'm going to talk to you about how you can get involved as we launch a class action lawsuit to try to correct this improper and illegal action by the Department of Education. Dr. Johnson?
Thank you, Devlin. It's a great honor to sit here with Devlin. He's one of the most thoughtful and informed attorneys that I've ever had the opportunity to meet with. I came to Attorney Cooper several months ago to express to him some concerns that I had about what I saw going on at the U.S. Department of Education. And specifically, what I brought to his attention was that there's been a restart to the federal student loan program. The Trump administration is hell-bent on making sure that people be held accountable for making their payments, which it's appropriate for people to do so. This is not about discussion of any debt cancellation or debt relief. What we're specifically wanting to talk about, or I wanted to talk to him about, was the fact that the Department of Education had not prepared itself operationally to be able to work with the millions of student loan borrowers who are ready and willing and able to start making their payments, but they just can't do so because they can't talk to somebody at the Department of Education or they can't talk to somebody at the servicing organizations. And so consequently, their accounts are just automatically rolling from one stage of delinquency, i.e. 30 to 60, to another stage of delinquency, 60 to 90, to another 90 to 20, all the way out to 270 days where they're being declared and technically to be in default. The Fair Credit Reporting Act requires that any data that goes into a credit bureau must be both fair and accurate. So we're hard-pressed to understand how if a borrower is trying to get themselves into repayment status and their creditor is failing to meet the responsibility of operationally enabling that, how the reporting of any delinquency associated thereto could be considered to be fair. Very frankly, the Department of Education knows full well that it is failing miserably on its servicing obligations. Each of the servicers who the department keeps referring potential borrowers to are failing and have failed miserably. We've got 10-hour wait times. We've got millions of pieces of mail in backlog. It just is just beyond comprehension how bad the interface capabilities that the department currently don't even provide or evidencing are. So the nature of the lawsuit that Devlin pointed out after the conversation basically boils down to that when the government operates on a commercial basis, in this case a profit-making basis, to make money off of federal student loans, that they have a responsibility if they're choosing to use a commercial application, i.e. reporting into credit bureaus, to provide some element of assistance to their process. Quite frankly, the only reason the department reports anything into the credit bureau is to use it as a back-end collection tool. Their whole strategy is, because I was there, I know what the strategy was. Their whole strategy was, if I get you reported as a serious delinquent or in default, you're eventually going to track me back down in order to try and get in good standing because you want to get credit. Well, that's even particularly terrible in this situation because even you can't reach them while you're trying to prevent going into delinquency default, and even if you're in default, you can't reach them in order to try and get out of default, and so you're in default purgatory. There's a little quick, an important aside on this is that in many cases, people are just flat giving up and willing to accept that they're going to be in this default purgatory for the rest of their lives. Many of these people would willingly accept filing for bankruptcy because at least there's definitive action in that regard. However, all this being said, the Department of Education is failing in its responsibilities. They're sending bad, inaccurate, unfair data to the bureaus. The credit bureau files, Equifax, Experian, TransUnion are knowingly accepting this information, and in turn, the credit industry, the credit card companies, the automobile loan companies, even the mortgage companies are relying or turning to this improperly reported data, which lowers credit scores, quite frankly, as a way to charge higher interest rates. So this legal action, hopefully, which you'll express an interest in continuing to be aware of and perhaps participating in, is all about bringing the federal government and the credit bureaus held to be accountable for their unfair and, again, what the attorneys will determine, illegal activities. Again, I'm Dr. Wayne Johnson. I have pretty good insight to what's going on, having served in the department before and having followed it for the past several years. The time for action has come, and I'd like very much for you to be a part of this action, and you can do so by going to studentloanlegalaction.org. I say again, that's studentloanlegalaction.org. Thank you.
We've launched a class action lawsuit that aims to remediate and fix these problems to your credit reports and the false information that the Department of Education is reporting. Many people believe that the federal government is immune from lawsuits, and it frequently is. But in 2024, the United States Supreme Court found that the federal government is the largest credit provider, largest consumer lender in America, is held to the standards of the Fair Credit Reporting Act and can be sued in that capacity. We've launched a lawsuit for a representative class of individuals that would include you, if you have been held in default already, to seek to have this false and inaccurate information removed from your credit reports. We also believe that each of you have been harmed financially already. When the credit bureau posts this false, misleading, and inaccurate information, it results in credit card companies and other lending companies and financial institutions increasing your interest rates to borrow money. That causes you direct financial harm. That's before we get to the opportunities of the federal government to garnish your wages or seek your Social Security payments. All of this has direct impact on you, and we're aware of that. We think each of you have been harmed no less than $100,000 already. And so as part of the class action, we'll be seeking payments for each of you to make you whole. More importantly, as I said, we want to get the false information off of your reports. The Federal Student Loan Program is the largest consumer loan portfolio in the world. It greatly exceeds the amount of credit card debt in America. And when the federal government decided in 2010 that it wanted to participate in the consumer lending world and compete with banks to provide student loans, it entered into a fiduciary obligation with each of you to do so appropriately, to act lawfully, to hold itself to the same standards as other lenders. It's failed to do so. It's time to correct that wrong and try to make each of you whole. We believe 5 million individuals have already been improperly held in default. We believe that that number will grow to 10 million by December of this year, 2025. We believe it'll grow to 20 million by April of 2026. If you'll go to studentloanlegalaction.org and submit your name and your information, we'll provide you with updates on our class action lawsuit, and we may follow up with you directly to include you as a named party in the suit. The reason we're bringing this as a class action is because there's a common set of facts, common relief sought, and the class is representative of all of your issues with the Department of Education as it pertains to these defaults, the credit bureaus, and the consumer lenders. By bringing a class action, Whether we name you as an individual in the suit or not directly in the caption of a case, all people who have been held in default improperly under this operative set of facts would be addressed by the relief ultimately awarded by any court or in any settlement. And so the goal, whether you sign up or not, is to make sure that you're made whole.
We've been talking about the harm that has been created because the United States Department of Education is unfairly reporting negative and defaulted credit bureau information into the credit bureau files. I'd like to highlight the relief that will be sought under a class action lawsuit. The first action will be anybody that's had negative or defaulted information reported in the bureau files since January 1st of 2025, that data to be removed. The second will be that all credit bureau reporting be suspended until it can be certified that the U.S. Department of Education is capable of meeting its operational responsibilities. The third is that each and every member of the class will receive no less than $100,000 in actual and punitive damages. And an additional element will be requesting that the President Trump issue an executive order stating that it will be the policy of the United States government to not challenge any bankruptcy filings for someone who files for bankruptcy on their federal student loans, provided that the person's last student loan borrowing for direct education purposes was made at least 5 years prior to the bankruptcy filings. We think these are fair and equitable elements of relief, and we believe it's something that can be acted upon quickly. What is needed right now are people to raise their hands and say that they would like to see these actions be pursued.
I want to assure each of you that there's no cost or financial obligation that you incur by signing up at studentloanlegalaction.org. The purpose of signing up is so we can provide you with information on our activities in this litigation and so that we can hear your story. Even if you're ultimately included as a representative named member of the class, you wouldn't incur any financial obligation to us unless we resolve this matter through a judgment, an award, or settlement with the federal government, the credit bureaus, or lenders. We only get paid if you get paid, and the percent we get paid would ultimately be determined by the United States District Court. We want to make sure that each of you are paid adequately for the harm that you've incurred. But that's not our sole purpose here. Our purpose is to ensure that the borrowers under the federal student loan program are no longer harmed by the Department of Education, by the credit bureaus, by lenders. Our purpose is to try to make you whole. And that is what we're going to zealously try to achieve through this litigation. But we'd appreciate hearing from you and hearing your story and being able to provide you information directly at studentloanlegalaction.org. Please sign up today.